5 seconds to go. Start. There are sufficient constitutional and legal remedies available for a citizen whose liberty is threatened by any person. Beyond the constitutional and legal remedy and protection available, there may not be any other additional duty to affirmatively protect the right of a citizen under Article 21. Cases of infringement of fundamental rights are taken care of under Articles 32 and 226. Conduct of public servants like a minister, if it is traceable to the discharge of public duty or the duties of the office, is subject to scrutiny of the law. Sanction for prosecution can be granted if misconduct is committed under color of office. Such misconduct, including statements that may be made by a minister, cannot be linked to the principles of collective responsibility. The concept of vicarious liability is incapable of being applied to situations, and no government can ever be vicariously liable for malfeasance or misconduct of minister not traceable to statutory duty or statutory violations for the purpose of legal remedies. Ministerial misdemeanors which have nothing to do with the discharge of public duty and not traceable to the affairs of the state will have to be treated as acts of individual violation and individual wrong. To extend in the abstract the liability of the state to such situations or instances without necessary limitations can be problematic. Post Messrs. Kasturi Lal Ralia Ram Jain versus the state of Uttar Pradesh, this court has treated misconduct of public servants or officers and consequent infringement of constitutional rights as ground for grant of compensation. However, there is a need for clarity and certainty as far as the conceptual basis is concerned. This may be better resorted through enacted law. While the principle of constitutional tort has been conceived and subsequently applied to provide in regard to the constitutional remedies, the matter preeminently deserves a proper legal framework in order that the principles and procedures are coherently set out without leaving the matter open ended or vague. Ms. Aparajita Singh, learned senior counsel and amicus curiae, submitted a written note, question wise, which can be summed up as follows. The right to free speech under Article 19(1)(a) is subject to clearly defined restrictions under Article 19(2). Therefore, any law seeking to limit the right under Article 19(1)(a) has to necessarily fall within the limitations provided under Article 19(2). Whenever two fundamental rights compete, the court will balance the two to allow the meaningful exercise of both. This conundrum is not new, as the rights under Article 21 and under Article 19(1)(a) have been interpreted and balanced on numerous occasions. Take for instance the Right to Information Act 2005. The Act balances the citizen's right to know under Article 19(1)(a) with the right to fair investigation and right to privacy under Article 21. This careful balancing was explained by this court in Thalapalam Service Cooperative Bank Limited versus State of Kerala. The decision of this court is another example of reading down the restrictions in the form of defamation on the right to free speech under Article 19(2) in its application to public officials and public figures in larger public interest. Again, in People's Union for Civil Liberties versus Union of India, the right to privacy of the spouse of the candidate contesting the election was declared as subordinate to the citizen's right to know under Article 19(1)(a). A challenging to sections 123(5) and 124(5) of the Representation of the People Act 1951 as they prevailed at that time was rejected on the ground that false personal attacks against the contesting candidate was not violative of the right to free speech. But when it comes to private citizens who are not public functionaries, the right to privacy under Article 21 was held to trump the right to know under Article 19(1)(a). This was in the case of Ram Jethmalani versus Union of India, which concerned the right to privacy of account holders. In Sahara India Real Estate Corporation Limited versus Securities and Exchange Board of India, this court struck a balance between the right of the media under Article 19(1)(a) with the right to fair trial under Article 21. The argument that free speech under Article 19(1)(a) was a higher right than the right to reputation under Article 21 was rejected by this court in Subramanian Swamy versus Union of India, Ministry of Law, in which Section 499 IPC was under challenge. The right to free speech was balanced with the right to pollution-free life in noise pollution, and the right to fair trial of the accused was balanced with the right to fair trial of the victim in Asha Ranjan versus State of Bihar. Stop.